Recording in progress.
Good morning, Chairperson. Good
Good
morning.
morning, Mr. Martins.
Yes, morning, Chair. It's 9 o'clock, and then we have enough members to start with the meeting, and also we have the department and the state law advisors there in the meeting. Over to you, Chair.
No, thanks. Good morning, honorable members. Morning, Minister, TM, the DGA, and your team, the state law advisors, parliamentary legal services. We are going to deal with these items which are on the agenda, and will allow members of the committee to interact with the issues that are arising from the presentation by the state law advisor. Members will recall that we've interacted on the immigration amendment bill in our last committee meeting when we were dealing with this item. And we did adopted the A list and directed the chief state advisor and the Department of Home Affairs to work on the bill list that will be presented to this meeting. We'll also receive a response from the department in relation to the one-stop border post. As you know, that we conducted public hearings and we've interacted with stakeholders also in written submissions, and we'll be affording the opportunity for the Department of Home Affairs to respond on all those issues that were raised, and also the parliamentary legal services to respond on all those issues that were raised. Will then afford members of the portfolio committee to comment or raise issues, and will step off the item so that we give enough time for members to go and further consult. Thereafter, we'll schedule for a deliberation. But the only area that we're going to adopt today is the amendment on the immigration bill once it has been presented and members have considered the issues that are arising on this matter. The second point, last week we dealt with the report of the 2024 provincial and national elections, and I think we've dealt in detail. We ought to get a schedule, Mr. Matonzi, to reflect as a committee on the issues that arise from the report, so that we consider the report and also the recommendations that we have already proposed, or members of the committee have highlighted some of the issues that the IEC may need to consider, and would think that that report must also find its way to be presented in the House. We're also going to receive an update on the process of the marriage bills public hearing. As you know, members, that we're working towards the deadline of the 24 July 2026. That includes the work that the National Council of Provinces ought to engage on, and also the consideration of the Parliament, both houses, including the work that the President needs to deal with. So this is a work that is continuously going to engage on this week. We're going to Free State, and the other scheduled date we're going to Northern Cape. I think the members of the committee would brief us, the Secretariat, and also the public education in terms of the work that is already being taken. I will now invite Mr. Matonsi to consider the item number 2, if there's any apologies, and introduce already those that were highlighted.
Okay, Chair, from my side, I've got an apology from Reverend Mishwe, and then also from Honorable Ngubane, who said no, is attending the higher education meeting, which is an urgent meeting. And then also Miss Mohammed said she would indicated that she will leave at 10. She's in the meeting at the moment. And then also there's an apology from the DG. Those are the only apologies I received, Chair.
Okay, thank you very much. Any other apologies, members? Okay, all apologies will be recorded as presented, and also the agenda. I think it has been considered. Is there any other issue that you want to raise on the agenda? Okay, noted. We'll now invite the Chief State Law Advisor to recap on the A list and the B list, and then we'll then deal with the report, and we'll move to the introduction of the responses from the department. I'm not sure whether it will be the DM or the minister. I only noted that the DM is in attendance. You can proceed, Ms. Govender.
Good morning, Honorable Chairperson, Honorable Members, Deputy Minister, and all others present in the committee this morning. I'm Ms. Sarah Govender from the Office of the Chief State Law Advisor, and on behalf of the Legal Services team made up of Parliamentary Legal Services, the Department of Home Affairs, as well as the Office of the Chief State Law Advisor, I have been tasked with presenting the finalized A list containing the agreed amendments by the Portfolio Committee and the B bill, which reflects these agreed upon amendments. I would just like to know if the committee is able to see.
Yes, correctly. Yeah, we can.
Okay, I just want to check if maybe I can share both. Is it just one that's showing, or is it two that's showing, Eddie?
I think it's close one.
It's only one document that is showing. The B list is not showing.
Okay, I'm not sure why it's doing that because I am trying to share both, but let me just try again and see if it works. Is it better now?
Yeah.
Yes.
Okay, thank you for that. Chairperson and honorable members, on the left side of the screen, the committee will see that the A list has been flighted. And on the right side of the screen, you will see the B bill, which is being displayed, which reflects
Mr. Matonzi?
Yeah, I thought maybe it was me. I can't hear anything from her.
Yeah, I think either she's muted or there's a network challenge.
Let me try to call her.
Okay, thank you.
The committee's only instances the A list.
I think Ms. Govender, your network is bad. I'm not sure how can you.
Chair, you able to hear me now?
Yeah. You can try. We'll advise if we're not
Okay. Okay, I
benefiting.
do apologize for that. I hope you can hear me now. As I was saying, the A list is on the left-hand side of the screen, and the B bill is reflected on the right, highlighting the changes from the A list. I will take the committee through these amendments, which is agreed upon and brought upon by the A list. These are the amendments agreed to on the Immigration Amendment Bill B8 of 2024, Clause 1, Point 1, on page 2 from line 10 to omit paragraph C and to substitute with the following paragraph. Shall be informed upon arrest and detention or immediately thereafter of the 1. Rights set out in paragraph A and subsection 1AG. 2. Reason for the detention. 3. Right to choose and to consult with a legal practitioner. And 4. Right to have a legal practitioner assigned to him or her by the state and at state expense, if substantial injustice would otherwise result, in a language that he or she understands when possible, practical, and available. And point 2 on the A list, on page 2 from line 17 to omit paragraph A and to substitute with the following paragraph. A1, the foreigner has been interviewed as contemplated in section 41(1). And 2, the immigration officer has considered whether the interests of justice, after taking into account the relevant factors that must be prescribed by the minister, permit the release of such foreigner, subject to reasonable conditions, and must, if he or she so concludes that the interests of justice permit the release of such foreigner, impose reasonable conditions and record the release therefore on a prescribed form. Point 3 on the A list, on page 3, in line 16, after the word make, to insert oral or written. And if we had to read it in context, paragraph G, a foreigner concerned brought before a court in terms of paragraphs B or E must be given an opportunity to make, and here you'll see the amendment, oral or written representations to the court, and such representations must be considered together with the representations by the immigration officer. Chairperson, these are the amendments that were agreed to by the Portfolio Committee in the A list and has been carried over and reflected in the B bill. Chairperson, we would also like to point out that there were technical amendments which were also affected to the memorandum on the objects of the bill, and this was done merely to align the memorandum on the objects of the bill to the actual contents of the bill itself. Thank you, Chairperson.
Members, these are the clause 1 on the reflection in the matters we've carried for the processing of the B list. Can we consider the clause 1? Is there any other matter on the clause 1 before we consider for adopting it? Okay, can I call hands for adoption of the clause 1? Honorable Ross?
Chair, I move for the adoption.
Thanks, Honorable Ross. Any seconder?
Seconded. Chairperson.
Thank you, Honorable Machi. Is there any other contrary view? Okay, the clause 1 is carried. You can proceed.
Chairperson, it was clause 1 that contained the amendments, and then it's just clause 2, which was a substitution of the word in Act 13 of 2002, which was the principal act is hereby amended by the substitution for the word court, which the capital C, wherever it occurs, of the word court with the lower C. That was clause 2, Chairperson.
Members, this the reflection of the matters we've carried in the A list. Can I invite any other comment on the clause 2? Can I invite hands for adoption? Honorable Ross?
Chair, I move for adoption.
Seconder? Honorable Mtolo?
I second, Chair. Thank you very much.
Thank you, members. Is there any other contrary view? Carried. There's been carried. We can proceed.
Clause 3, Chairperson, is the short title and commencement. This act is called the Immigration Amendment Act 2025 and comes into operation on a date determined by the President by proclamation in the Gazette.
Those 3 members, can I invite hands for comment? Can I invite hands for adoption? No rules.
Chairperson, I move for the adoption.
Thank you, Seconder. Honorable Matapo.
I second, Chair. Thank you.
Any contrary view? Noted. The clause 3 has been carried. The short title and a commencement. We can proceed.
Chairperson, those were the 3 clauses in the bill, Chairperson, and there are no others.
Thank you, members. Done now that we've Honor Ross, is the legacy hand?
Legacy hand, Chair.
Okay. Members, now that we've deliberated in our previous meeting and adopted the A list for processing of the B list, this is a reflection of the collective members of the committee in the reflection of the amendment, immigration amendment bill. And therefore, we've carried adoption of the B list. Mr. Matonsi, you will proceed with the report.
Yes, Chairperson. So this is the report that the committee needs to adopt today. I'll just go through it word by word. Report of the Portfolio Committee on Home Affairs on the Immigration Amendment Bill, B8 2024, dated 22 July 2025. The Portfolio Committee on Home Affairs, the committee having considered the subject of the Immigration Amendment Bill, B8 2024, referred to it and classified by the Joint Tagging Mechanism as a Section 75 bill, reports the bill with amendments B8A 2024. Point 1 is on the 29th of June 2017, the Constitutional Court in the Lawyers for Human Rights and Minister of Home Affairs and others declared Section 34(1)B and D of the Immigration Act 2002, Act number 13 of 2002, the Immigration Act, inconsistent with Section 12(1) and 35(2)D of the Constitution of the Republic of South Africa, 1996. The Constitution therefore invalid. The Constitutional Court held that Section 34 of the Immigration Act was unconstitutional since it did not require automatic judicial review of a detention before 30 calendar days expire. That Section 34(1)D was unconstitutional because it did not require the appearance of the detainee in person before any decision to extend the detention for a further 90 days. And that Section 34 was unconstitutional because it conferred a power to detain without any objectively determinable condition or guidance for how that power is to be exercised. In addition, the Constitutional Court noted that Section 34(1) does not require that a detainee be informed of the rights set out in Section 35(2) of the Constitution, in particular, the right to legal representation by a lawyer of their own choice or to be assigned one at the state expense if substantial injustice will otherwise result. Number 3, the declaration of invalidity was suspended for a period of 24 months from the date of the order to enable Parliament to correct the defects in Section 34(1)B and D of the Immigration Act. In a supplementary judgment delivered on 30 October 2023, namely the ex parte Minister of Home Affairs and others, in the Lawyers for Human Rights and Minister of Home Affairs and others, the Constitutional Court ordered as follows. 1, subject to and pending the enactment of legislation outlined in paragraph 2 as from the date of this order, pending remedial legislation to be enacted and brought into force within 12 months from the date of this order, the following provisions supplementary to those contained in paragraph 4 of this court order of 29 June 2017 shall apply. An immigration officer, that's number A, considering the arrest and detention of a legal foreigner in terms of Section 31 of the Immigration Act 13 of 2002, must consider whether the interests of justice permit the release of such person subject to reasonable condition and must not cause the person to be detained if the officer concludes that the interests of justice permit the release of such person subject to reasonable condition. B, a person detained in terms of Section 34(1) of the Act shall be brought before a court within 48 hours from the time of the arrest, no later than the first court day after the expiry of 48 hours. If 48 hours expire outside the ordinary, or if 48 hours expire out of the ordinary court days. C, the court whom a person is brought in terms of paragraph B above must consider whether the interests of justice permit the release of such person subject to reasonable condition, and must, if it is so, conclude that person to be released subject to those reasonable conditions. D, if the court concludes the interest of justice does not permit, the court may authorize the further detention of the person for a period not exceeding 30 calendar days. If the court has ordered the further detention of a person in terms of paragraph D above, the said person must be brought before the court before the expiry of the period of detention authorized by the court, and the court must again consider whether the interests of justice permit the release of such person subject to reasonable condition, and must, if so, conclude order that person to be released subject to reasonable condition. F, if the court contemplated in paragraphs E above conclude that the interests of justice do not permit the release of such person, the court may authorize the person's detention for an inadequate period of not exceeding a further 90 calendar days. A person brought before a court in terms of paragraph B and E must be given an opportunity to make representation to that court. If the remedial legislation is not enacted and brought into force within the 12-month period, the provision in paragraph 1 above shall continue to apply until such remedial action is enacted and brought into force. Close quote. Then on the 5th of April 2024, the Minister of Home Affairs introduced the Immigration Amendment Bill, B8 2024, the bill into Parliament to address the finding of the Constitutional Court. The bill was referred to the committee for further processing. The bill, as introduced, broadly seeks to amend section. The amendment is amend section Immigration Act 2004 as to revise provision relating to the arrest and detention of illegal foreigners for purposes of deportation, and to align this provision with the constitutional principles. And 6B62 provide for methods connected therefore. On number 7, on 27 August, the Minister of Home Affairs and the Department of Commerce were invited to brief the committee on the content of the bill, and then on 19 October 2024, the bill was published for public comment in all official languages. The closing date for such comments was 22 November 2024, and about 378 submissions were received. Number 8, on the 11 and 18 February 2025, the committee conducted public hearings on the bill. The committee resolved that the bill will not be subjected to provincial public hearing. The following stakeholders made the submission to the committee. That's Lawyer for Human Rights and International Detention Center, South African Human Rights Commission, Center for Social Justice, Calabrin Center of Cape Town, Commission for Equality, for Gender Equality, Center for Child Law, United Nations High Commission for Refugee, Clayville Civic Association, African National Congress, and COSATO. And then on 14 March 2025, the Department of Home Affairs, together with the Parliamentary Legal Service, provided response to the submission received and issues submission received and issue raised during the public hearing on the bill. And then on 18 March, the committee adopted a motion of desirability to propose to proceed with the processing of the bill and commence with its deliberation. Further deliberation took place on 6 and 20 May 2025, as well as 3 June. Following this section, the committee instructed the Parliamentary Legal Service and the Office of the State Law Advisor to prepare a list of proposed amendments to the bill. The list of proposed amendments was presented to and approved by the committee on 10 June. The committee subsequently conducted a clause-by-clause on the bill and adopted the report on the bill on 22 July 2025, reports to be considered. That's the report, Chairperson.
Thank you very much, Mr. Matonsi. You are requested to accept Honorable Ngubane back on the Ngobeni. Members, can we then consider or comment on the report as a true reflection of the process that we facilitated this engagement since the tabling of the Immigration Amendment Bill to Parliament and referred to the portfolio committee, and a consultation was conducted, written and also oral, and also deliberation by members of the committee for the adoption of the A list and subsequent adoption of the B list. And this report reflects those areas we have highlighted to date. Is there any other matter before we consider adoption that is not reflecting or captured properly on the report? So that will suggest that is can I check with the Parliamentary Legal Services? If there may be a matter.
Good morning, Chairperson and members. This is Daksha. We agree that the report reflects the process followed in the committee. Thank you, Chair.
The Chief State Law Advisor.
Thank you, Chairperson. We have had sight of the report and we believe that it does correctly capture the process that is unfolded in the bill. Thank you, Chair.
Thank you. Department of Home Affairs, Advocate Malikata.
Good morning, Chair, and good morning, members of the Portfolio Committee, Deputy Minister. Yes, we have had sight of the report and it does carry the processes that have been followed. Thank you.
Thank you. Members, I think we've called just to check before we invited our stakeholders if there may be other technical matter that we might have omitted in our drafting. It will appear that it's a reflection of the engagement on this process. Can I now invite hands for adoption of the report?
I raise to adopt, Chair.
Thank you, Honorable Lemachi. Seconder? Honorable Ngobeni?
Seconded. Seconded. Thanks.
Any objection? Thank you very much. The report has been carried and will then be subjected to the process of the tabling to the House. Can we step off the item, Mr. Matonzi?
Yes, Chairperson. Now it will be the department on the one-stop border post.
Okay, thank you very much.
Honorable Chairperson, can we please be excused? Parliamentary Legal Services.
I'm not sure. I thought you are part of the.
It's one of our colleagues. It's not Daksha and myself.
Chairperson, there is somebody who's dealing with the one-stop border post. Ms. Leotla is here in the meeting, so he will take us through when it comes.
Okay. All right. Oh, perfect. No, thanks very much, colleagues. You can take leave.
Thank you so much.
Can I now invite the Deputy Minister to introduce the responses on behalf of the department? Then he will delegate for processing.
No, thank you very much, Chair, and good morning to yourself and the members of the Portfolio Committee. Today I'm here with the BMA Commissioner, Commissioner Masia Pato, as well as the acting DDG, Mr. Yusuf Simons, as well as Advocate Malakate, whom I think you know very well from the Portfolio Committee. We've been working together throughout the processing of the amendments on the immigration bill, as well as the one-stop border post. Chairperson, we're here to then give you responses in terms of the one-stop border post. These are DHA as well as BMA, which means both Home Affairs as well as Border Management Authority collective responses on the oral as well as written submissions. You will remember, Chair, that there was an analysis on the submissions that was done by the content advisor on the 6th of May 2025, as well as the oral submissions that the committee had on the 27th of May 2025. Now we'll go through them clause by clause, but for me it's just to remind the members that the bill actually seeks to regulate the establishment of the one-stop border post as it pertains to international agreements, as well as common control zones, as well as processing agreements. Now, some of the comments that have been made are mainly operational as well, which have to do with congestions and how we manage our border environment in terms of those border posts. I can indicate, Chair, that we are very much at an advanced level in terms of concluding the process of sourcing partners for the development of the 6 ports of entry. And this policy will then play a huge role. It's one of the biggest infrastructure projects that this country will see through the development of those 6 ports of entries. Now, I would think that Advocate Malakate will then take us through clause by clause submissions that were made, as well as our responses to them. Safe to say, Chair, that we do not have many contentious issues in this regard. Mainly, it will be smooth sailing, but I think we'll give the space to Advocate Malakate to then deal with the issue. Thank you, Chair.
Thank you, TM. Thank you, TM, for those remarks. Advocate Malakate.
Good morning once again, Chair and members of the Portfolio Committee, Deputy Minister, Commissioner for the Border Management Authority, as well as the Deputy Director General for Immigration Services. Chair, where we would want to start if Mr. Edmatonsi could flag the presentation that we had submitted to the Portfolio Committee, if it's possible. But where we would start on slide 6, because the Deputy Minister has already dealt with the introductory remarks relating to this. And we can also remind the committee that in the May, we got a written submission and there were oral submissions from invited institutions. In the main, it was the Office of the High Commissioner for Human Rights, Scalabrini Center for Cape Town, South African Catholic Bishops Conference, Lawyers for Human Rights, the Consumer Goods Council of South Africa, the Congress of South African Trade Unions, as well as 2 individuals, Zaki Desai and Tato Silike. When it comes to Eddie, if you can go to slide number 6, in dealing with the bill, the Scalabrini and the Office of the High Commissioner on Human Rights, as well as the South African Catholic Bishops Council, had submitted written representations and oral representations relating to clause 1, which deals with the definitions. In the main, they were making suggestion that the bill, clause 1, should define what is an asylum seeker, a refugee, a child, what is an unaccompanied migrant child or an unaccompanied child or children, stateless persons, as well as separated migrant children. And then OHCHR then suggested that there has to be an insertion of asylum seeker visa. The Bishops' Conference also suggested that the definitions must be aligned to international protocols for consistency. On the next slide, the Commission, the Consumer Goods Council, wanted us, or wants the committee to consider including the definition of what is meant by official use, and this will then relate to clause 6 of the bill. In our response, we indicating that most of the definitions that are being suggested, they already exist in our current jurisprudence in other pieces of legislation. For instance, if we were to go to look at the Immigration Act as well as the Refugees Act, these definitions already exist. And therefore, the one-stop border post bill does not need to invent the wheel and reinsert provisions that are already in existence. And similarly, there is no need for us to define something which perhaps in this bill may differ from what is already existing in the principal legislation. And therefore, we are of the view that the definition, clause 1 as it is, covers everything that is required to be covered. So in the next slide, we only reminding the committee that one of the critical issues in defining or inserting definitions in a bill is that definition perform two functions. Namely, it seeks to avoid any ambiguities that may arise, but also to look to avoid, by means of maybe abbreviation, any tedious repetition. And therefore, we submit that the bill must be read in tandem with domestic law, and there is no need for the insertion of the suggested definitions because they already exist in other pieces of legislation. The next slide deals with clause 2, and where the Office of the High Commissioner on Human Rights is recommending that the clause 2 should be expanded to include an interpretation provision requiring the bill to be interpreted and applied consistently with international human rights and refugees instruments. And they have then mentioned the 1951 Refugee Convention as well as the 1967 Protocol on the Protection of Refugees as well as the AU Convention. And they are indicating that the provision should then be aligned to what Section 1A of the Refugees Act indicates. We submit that this bill, the purpose of this bill is only to empower the Minister of Home Affairs with the power to establish, of course, with the concurrence of the adjoining state, a one-stop border post. And when it comes to issues related to the international human rights state protocols and refugee law instruments, when the officials of the Republic are executing their functions or powers or duties, they would do so in line with the international instruments, but they will ensure that there is compliance with international instruments and those international instruments that the Republic is signatory to. The next slide then deals with clause 3, and clause 3 empowers the Minister of Home Affairs to establish within the one-stop border post common control zones, and of course in concurrence with the adjoining state. Scalabrini Center as well as the Bishops' Conference have expressed concern relating to the broad powers that seem to be granted to officials of the Republic under clause 316 and the 31C. This clause 31C deals with issues related to arrest, search, seizure, and detention. And they submit that clause 31C must explicitly refer to the constitutional and international instruments safeguards. Scalabrini then further recommends that clause 31C, Roman numeral 2, must include reference to fundamental rights under Chapter 2 of the Constitution, as well as South Africa's public international law obligations, in particular regarding the protection of vulnerable groups. In response, we are again reiterating that the bill, the purpose of the bill is to empower the minister to establish one-stop border post, and that issues related to Chapter 2 or South Africa's international obligations would be carried over, but in executing their functions, officials of the Republic will ensure compliance with international obligations as well as the domestic laws. And therefore, the powers of arrest, search, and seizure and detention are in line, in our view, with domestic laws as stipulated in the various border law enforcement legislation that the Section 97 proclamation under the BMA seeks to deal with. In the next slide, we note that the Consumer Goods Council then recommends updating clause 3 to clearly stipulate that the minister, in concluding the international agreement with the adjoining state, should not exempt any official from the application of current laws. And we confirm that properly understood and properly read, the bill does not seek to exempt officials from complying with any international instruments. And in fact, in executing their functions, officials will be required to ensure compliance. Further, officials will be required to ensure that there is compliance with domestic law and within the one-stop border post or exclusive areas, the laws of the Republic will be applicable in its entirety. And that also means that there would be compliance with international instruments. In the next slide, Chair, we then deal with clause 4 of the bill, which deals with the application of border law enforcement legislation within the one-stop border post. And COSATU then raises concerns that the bill is silent on the specific roles, legislative mandates of the Border Management Authority, as well as the South African Revenue Service, South African Police Service, and the South African National Defence Force within the OSBP context. COSATU then proposes that the insertion of a clause that then reaffirms these legally binding rules of these institutions to prevent the usurping of functions. For instance, they give an example that the BMA should not be able to take over the roles of the constitutional role of South Africa, of the South African Revenue Service. Scalabrini Center then highlights its concerns about the lack of clarity regarding responsibility and potential rights abuses. And they then indicate as an example that asylum seekers should not be bounced between officials of the Republic and those of the adjoining state within the common control zones where the laws of both states apply. They then link this argument to clause 4 of the bill. Then in the next slide, the Lawyers for Human Rights then submit and note that while clause 4 addresses the applications of the border law enforcement legislation within the one-stop border post, it does not adequately address the potential conflicts between substantive laws of the Republic and the adjoining state, particularly concerning human rights or treatment of migrants. In the next slide, we then provide our response in the next slide and submit that, of course, within the one-stop border post, the customs services within the South African Revenue Service will continue to execute its functions as contemplated in the tax administration laws within the Republic. Similarly, the South African Police Service performs its functions, powers, or duties as it is contemplated in the South African Police Service Act within the one-stop border post. And we then go further and indicate that the committee will recall that the commissioner for the BMA has submitted previously that there are currently ongoing discussions within the Justice, Crime Prevention and Security Cluster on the matter. Further, that the South African Defence Force exercises its powers in line within the borderline, in line with Section 200 subsection 2 of the Constitution, read together with the Defence Act. And of course, there should not be any conflict in terms of how they apply their functions, because their functions differ in terms of the legislation that empowers them to do certain things within the border post. We then continue in the next slide to submit one of the pillars for establishing the one-stop border post is the adoption and approval of the procedures manual between the state parties. And this manual will then outline the operational guidelines as well as the protocols for managing and streamlining border crossings between the adjoining states. The manual will further reduce congestion or delays by consolidating border control procedures into a single location, and it's essential to facilitate trade, travel, and regional integration. We are of the considered view that once the procedures manual is agreed between the adjoining state, it will then properly indicate and ensure that asylum seekers are not bounced off between officials of the Republic and the other state. So it will clearly, the procedures manual will then clearly delineate when a person would be considered to have exited from the exiting country, and when he or she is deemed to have entered the Republic or the receiving state. In the next slide, we deal with clause 5. Clause 5 deals with the application of the criminal laws within the one-stop border post, and Scalabrini Center then recommends that clause 5.1 should be amended to refer to non-political criminal offenses to align with the refugee laws, which protect against return for political crimes. They further note the dual jurisdiction framework, which may lead to enforcement conflicts where the laws differ significantly, and recommend the introduction of clear conflict resolution mechanisms. ZEC, DESI, as well as the Lawyers for Human Rights, then knows the dual jurisdiction framework and the lack of procedure for resolving conflicts of laws that may arise under this clause. And they therefore propose the insertion of a new clause 5, subclause 5, capital letter A, that details the dispute resolution mechanism, and which would then deal with the negotiations, deal with mediations, as well as the court application. In the next slide, Chair, we then indicate and reiterate the functions and how the officials of the Republic within the one-stop border post, how they will not only ensure compliance with domestic laws, but also with international instruments. And in view thereof, we also indicating that in executing their functions, they would then be guided by the provisions of the Refugees Act, and they will ensure that whatever that is the mandate of what comes out of the Refugees Act would be adhered to, and they complied to. And therefore, we wish to submit that the issues relating to dispute resolution, it is an operational matter and should be dealt with in both the international agreement that will be concluded between the adjoining state in order to establish the one-stop border post. But also, if there is a need, the procedures manual will also deal with those aspects relating to how disputes will be resolved in the event that they had arisen between the adjoining states. In the next slide, we're dealing with clause 6. Clause 6 deals with the free transfer of money or goods within the common control zone. The Consumer Council of South Africa then strongly objects to this clause, and they have argued that it grants officials, both of South Africa and the foreign state, an unfettered freedom to move money or goods across borders for the undefined official use, without complying with any import, export, or entry or exit laws, including customs and exchange controls. And the Consumer Council then views this as a major loophole for corruption, money laundering, illicit trade, especially when they refer to the Financial Action Task Force, and they, as well as they note that similar legislation in the East African community, i.e. Zambia and Zimbabwe, is far more constrained or lacks such a provision entirely. And they then recommend the deletion of the clause in its entirety. ZEC recommends adding measures to prevent the exploitation of this provision for illicit activities like money laundering or smuggling. In the next slide, we submit that clause 6 in the main is intended to ensure that goods or monies collected within the one-stop border area and for official purposes are not subjected to taxation by the state parties. In other words, clause 6 seeks to exempt from taxation all monies collected in relation to enforcement of border law enforcement legislation or goods used or to be used for official business. And the term official use is generally understood and we are therefore of the considered opinion that the bill does not need to have an insertion and define this term because it's generally understood. The term, the ordinary dictionary meaning of the term will then be used. So monies or goods that are in possession of officials which are not for official use, these monies or goods are not exempted from taxation in terms of the domestic laws of the adjoining states. And we therefore submit that clause 6 is imperative and should not be deleted because it ensures that the officials of the Republic, for instance, are able to execute their functions within the one-stop border post. In the next slide, we deal with clause 7, which deals with an obligation to readmit. And OHC, HR, Scalabrini, the Bishops' Council and Lawyers for Human Rights expressed significant concerns with this clause. And in their view, it undermines the principle of non-refoulement. And then they then tabulate the various clauses or paragraphs within clause 7 that they have concerns with. And in the main, it's about the protection granted to asylum seekers and to ensure that when a person is claimed asylum, that the principle relating to non-refoulement, it's not taken into account. And LHR then knows that this should apply beyond the common control zones, and that the mandate relating to readmission potentially may force the return of individuals who are facing harm and prevent the exit state from taking protective measures. In the next slide, they then recommend that clause 7 must explicitly incorporate and be subject to the principle of non-refoulement and ensure that protection for asylum seekers, stateless persons, that those people are protected regardless of the entry method into the territories of the adjoining state, and that they are of the view that reference should be made within this bill to the relevant sections of the Refugee Act as well as the International Convention. The Consumer Council then comes in and refutes clause 7 as imposing undue and potentially burdensome obligation on the state of exit, potentially creating operational challenges. In the next slide, the first thing that we do is to reiterate that in performing their functions, officials of the Republic will comply with the entire Refugees Act and in particular with the principle of non-refoulement, and they will ensure that that whatever that they do should not offend the principle. And we further submit that the procedures manual, as we have previously indicated, will then deal with the operational processes between the state parties within the common control zones. As further, that clause 7 is essential to ensure that the state of exit bears the responsibility to readmit any inadmissible person or vehicle that has been refused entry into the Republic. Deleting this provision will render the operational procedures within the border post cumbersome and therefore will ensure or will render non-compliance with domestic laws. And in this case, we can make an example that in terms of the Immigration Act, those who are inadmissible may be refused entry into the Republic. The next line then deals with the general comments or contents or suggested amendments in the text of the legislation, and we have classified that and looking at the analysis that has been provided by the content advisor and dealing with the themes. Overall, when it relates to the overall objectives of the bill and the preamble, COSATU, Scalabrini, and the Bishops' Conference generally supports the bill's objectives as for improving efficiency and easing congestion and boosting trade or tourism. Scalabrini then recommends adding a clause that will deal with combating corruption and protecting fundamental human rights as it appears under Chapter 2 of the Constitution to the aims of in the preamble. Tato Siliki as well as Zex Desai then recommend amending the preamble to generally explicitly reference to regional or international obligations and other frameworks. And they then mention examples of the South African Development Community Protocol on Trade, as well as the Africa Continental Free Trade Area, and those agreements that would have been entered into and to ensure a smooth processing related to border management. In the next slide, the department we then respond and note the concerns that have been raised by both COSATU, the Bishops' Council, as well as Scalabrini, relating to improving efficiency and easing congestion and boosting tourism. We then submit that the BMA was established to improve and to deal with those issues that have been raised. And we can confirm that as of today, the BMA is performing those functions, in our view, successfully. The Republic does have legislation, Chair, to deal with corruption and protecting fundamental rights. And therefore, it is not necessary for the OSBP bill to deal with such, because in executing their functions, officials will comply with the Constitution, the domestic law, as well as the international instruments. Then Tato, again, this is a repetition, Chair. We can move on to the next slide, which deals with the human rights protection and international law alignment. And the concern here is that the bill, there is a need for the bill and subsequent agreements or operations to explicitly incorporate and prioritize constitutional and international human rights laws, refugees laws, and the principle of non-refoulement. And there were concerns raised about the lack of explicit safeguards for individuals, especially vulnerable groups within the common control zone. In the next slide, we reiterate that in our response that the agreements that the minister will enter into, as well as the procedures manual that will be agreed to between the adjoining state, will then clearly deal with these operational issues. And in our view, these are operational issues. They are not legislative, and therefore the bill should not deal with this and cannot then prescribe how the terms and conditions of an international agreement. However, the procedures manual, we indicate that it was clearly spell out the operational procedures that would then deal with the admission as well as the departures from the territories of the states in question. In the next slide, we dealing with corruption and oversight. The Scalabrini, COSATU, Lawyers for Human Rights, the Bishops' Conference, as well as Tato Siliki, highlight the risk and prevalence of corruption at border posts. And they express the concern that the bill lacks specific mechanisms to address or combat corruption. And then the recommendation then becomes that the bill should specifically incorporate anti-corruption measures, potentially drawing from the mechanisms that appear in the Refugees Act under Section 20A, or establish an independent border oversight authority. And the Lawyers for Human Rights then indicate that the bill should ensure that there is proper accountability as it relates to issues related to corruption and oversight. In our response, Chair, in the May, we then, in the next slide, we then indicate that the current domestic laws within the Republic, there are sufficient current domestic laws that regulate or that deals with anti-corruption and oversight. And we think that those are sufficient, and because the issues related to corruption and oversight are beyond the scope of this bill should not then deal specifically with those issues. In essence, the bill cannot then, we then submit that the bill should not be read in isolation of domestic laws. But then we just again reiterate that there are other, the international agreements and the procedures manual will also be available to deal with the issues. When it comes to role clarification between what the BMA, the South African Revenue Services subs and the SADF does within the border post, as well as resourcing, COSATU then raises a concern that the bill is silent on the need to ramp up enforcement capacity and to ensure that the BMA and other agencies are properly resourced to fulfill their mandates effectively within the one-stop border, under the one-stop border post model. And they also are concerned about potential job losses for existing officials, despite the need for more staff. Then in the next slide, Chair, we then indicate that, well, issues relating to the resourcing of the BMA as well as other agencies fall within the scope, outside of the scope of this bill or the objectives of this bill. However, we do note the shortfalls in the funding of the BMA as presented by the Chief Financial Officer to the committee. The Commissioner is also seized and will continue its efforts to request funding from National Treasury to enable the BMA to effectively execute its functions. But as we have previously indicated, there are clear provisions within the legislations governing the agencies or the entities that have been mentioned that clearly define the roles and responsibilities of those institutions within the border environment. In the next slide, we deal with the vulnerable groups. And in the main, Chair and members of the Portfolio Committee, there is emphasis that there needs to be specific provisions and sensitivity towards vulnerable groups, including issues related to proper identification, proper processing in accordance with international standards, as well as access from the vulnerable groups to social workers and protection against arbitrary detention or non-refoulement principle. Scalabrini then further knows the lack of practical support that may be provided, like there is no appropriate signage currently within the border post. Then in the next slide, we then reiterate what that there would be procedures manual agreed between the adjoining state that will then properly indicate the processes that will be followed in relation to exit and entry procedures. But it is imperative to reiterate that also in executing their functions, the officials of the Republic will be duty-bound to comply with domestic laws as well as the international instruments that South Africa is signatory to. And issues related to signage, Chair, and all other operational issues, this will be dealt with either in the agreements themselves or the procedures manual to be developed and agreed to by the state. The other issue that we'll submit is that signage relating to in the currently, those are issues that the Border Management Authority is seized with and is dealing with. In the next slide, then there's a general comment or concern from COSATU relating to the fact that the bill was not tabled before NEDLAC for engagement with the social partners and prior to its tabling in Parliament, despite the prior agreement between NEDLAC and the department. And this was in its view, it's in violation of the NEDLAC Act. The response that we are providing, Chair, is that we are noting in the next slide, we note the concerns and take into account the concerns from COSATU that have been submitted. But we also note the fact that COSATU, in its written or an oral submission, has indicated that despite its concerns relating to the tabling of the bill at NEDLAC, COSATU still supported the bill, and we appreciate that. And we further take into account and acknowledge that it is also imperative that all bills that affect the constituencies at NEDLAC should be subjected to NEDLAC processes. And the executive just wish to reiterate and confirm that all bills will then be referred to NEDLAC accordingly. In the next slide, then the submission deals with infrastructure, technology, and funding. Although it does not deal with the bill, these are general comments, and just simply to indicate that there has to be efforts and put in to ensure that the infrastructure is modernized and developed, that the technology must be introduced in order to ensure efficient and proper border management. And in our response, we note this comment, and we also indicate that the bill only seeks to deal with one-stop border post and common controls, funding and infrastructure development and technological development at ports of entry. They fall outside of the scope of this bill, but these are issues that the BMA and the Commissioner will also confirm that these are issues that the BMA is on a daily basis seized with and is dealing with that. The next slide then deals with issues related to environmental or socio-economic impacts. And in the main, that the submission is that the bill should recommend how it's going to address any potential socio-economic impact on border communities. And we just simply want to indicate that if you were to look at the BMA Act, there is a provision in the BMA Act that requires that the BMA must constantly and should liaise with border communities whenever and in dealing with issues related to border management. And we have taken note of the concerns that have been raised, but we are of the view that they fall out of the scope of the bill. In the next slide, the next issue that is raised relates to holding facilities within the ports of entry. And the main concern there is simply that the holding facilities that have been mentioned in the policy itself, although the bill does not deal with that, there is a warning, or the concern is that the department, the Republic, must guard against creating those holding facilities and hold people in those sites for prolonged period, and that those sites should not be replaced as administrative detentions, and argues that administrative detention and recommend that those facilities are used and in line with the international instruments and protocol. In our response, we just reiterate that the Immigration Act indeed sufficiently deals with this matter, and that this matter falls outside of the scope of the bill. And however, the concerns have been taken into consideration and will be carried over in the further development of the white paper on citizenship, immigration, and refugee protection. In the next slide, the concern relates to, or the submission relates to, training and capacity building, as well as public awareness. In the main, the submission is that the members of the border guards should be properly trained in issues related to custom, immigration, and security procedures. And then there has to be proper public awareness. And we do confirm and take note of that. And we confirm that there would be necessary training will be provided to officials of the Republic, and that the executive, that we further submit that post promulgation of this bill, the BMA officials will also be retrained on the mandate of the BMA. Chair, in the next slide, it deals with monitoring and evaluation, and the submission is simply to ensure that there are periodic reviews and assessment of the implementation of the one-stop, and using the matrix relating to processing times, trade volumes, as well as stakeholder satisfaction. And we have noted the comment, and we think that the BMA will deal with this issue relating to evaluation of its effectiveness of the functions that it executes within the border environment. And as we have previously indicated, there is an obligation on the BMA to ensure that it consults with its stakeholders. And Chair, that is in the main the response from the executive, and the executive we mean both the BMA as well as the department. Thank you, Chair.
Thank you very much, Advocate Malekate and Commissioner Mashiapata. We'll now move to receive Parliamentary Legal Service responses.
Good morning, Honorable Chair, Honorable Deputy Minister, Honorable members and colleagues. I'll try to flight and put on the screen the presentation in a moment. Not sure whether it's visible.
Yeah, we can proceed. We've seen it. Yeah.
Thank you very much. The scope of the presentation is as follows. I will deal with the introduction, the background, the public submissions and our responses, as well as the conclusion. The purpose of this presentation is to provide the Portfolio Committee on Home Affairs on the public submissions on the One-Stop Border Post Bill. The Constitutional and Legal Services Office, which is our office, considered numerous public submissions made on the bill, and we hereby now respond as follows. These public submissions were outlined by the Content Advisor on the 6th of May 2025. The submissions made the first submissions related to the expansions of the definitions. The following were recommended to be included in the bill, which is those words: asylum seeker, refugee, child, unaccompanied migrant child, unaccompanied children, separate migrant child, separated children, stateless persons, and official use. The definition part of the bill is aimed at defining words as they are used in the bill in order to provide their clear meaning as they appear in that bill. Where those words carry a different meaning or connotation other than the ordinary grammatical meaning. So our view is that it is not necessary to define words that do not appear in the bill itself. Most definitions that have been suggested, or the definition of the words that have been suggested, do not appear in the bill and therefore need not be defined therein. With regards to clause 2, relating to the application of the Act, the Office of the High Commission on Human Rights recommended that the applicability clause be expanded to include interpretation provisions requiring the Act to be applied consistently with international human rights and refugee law instruments. The bill seeks to regulate the establishment of an one-stop border post through international agreements, and to provide for the establishment of common control zones in the territory of an adjoining state, and to provide for a one-stop border processing arrangements, to authorize the application of the laws of the Republic and the adjoining state in the one-stop border post. This bill will apply outside the borders of the Republic of South Africa in accordance with international agreements entered into between the Republic and other states in terms of Section 231 of the Constitution. With regards to clause 3, Scalabrini Center expressed concern about the broad powers granted to officials relating to arrest, seizure, detention, without specific reference to constitutional and international human rights safeguards. The South African Catholic Bishops' Conference recommends that clause 3(1)(c) must ensure rigorous implementation of constitutional rights and protection of vulnerable groups. Zagdisai recommends that clause 3 be amended to specify timelines and consultation process for designating one border post. Our response is as follows. The process of designating a port of entry is provided for in terms of Section 30 of the Border Management Authority Act. It is therefore not necessary to reiterate that function in this bill. With regards to clause 4, COSATU recommends that the specific roles of and legislative mandate of the Border Management Agency, South African Revenue Services, South African Police, and South African Defence Force be specifically mentioned. The Scalabrini Center raised concerns about lack of clarity regarding responsibility and potential for human rights abuses. And the Lawyers for Human Rights concern is that while clause 4 addresses the application of border enforcement laws, it doesn't address potential conflict between adjoining states. And our response is as follows, that the Constitution as well as the South African Police Act Defense Act of 2002, Border Management Act clearly set out the mandates of each role player. So it is not necessary to reiterate those mandates in this bill. Observance of human rights is fundamental and protected by Chapter 2 of our Constitution. Relating to Clause 5, the Scalabrini Center recommends that the amendment of Clause 5.1 to refer to non-political criminal offenses to align refugee law principles which protect against return of political crimes. It further suggests that dual jurisdiction framework may lead to enforcement conflicts where laws differ. ZDSI notes that the dual jurisdiction framework and the lack of procedure for resolving conflict of law that may arise, a dispute resolution has been proposed. Official and other functionaries are under an obligation to comply with all laws in the execution of their duties and functions in terms of international instruments and treaties. So this post-resolution mechanism will be incorporated in the international agreements and not in the bill because they are operational issues. With regards to Clause 6, the CGCSA strongly objects to Clause 6 and argues that it grants officials unfettered freedom to move goods across borders for undefined official use without complying with any import or export laws and recommends the deletion of the clause in its entirety. ZDSI recommending adding measures to prevent the exploitation of this provision. Clause 6 is intended to ensure that monies and goods collected within a one-stop border area for official purposes are not subject to taxation. This serves as a tax exemption for goods used for official purposes. There is therefore no need to delete the clause from the bill itself. With regards to Clause 7, the OHCHR, Scalabrini Center, and the Lawyers for Human Rights express a common concern that this clause undermines the principle of non-refoulement. The main being the Clause 7.1a allows the state of entry to decline admission without exception for those seeking asylum. Clause 7.1b potentially allows for refoulement based solely on illegal entry, and Clause 7.1c, which mandates readmission by state of exit, potentially forcing the return of individuals to harm. Our response is that the official principle, the principle of non-refoulement is incorporated in the provisions of the Refugees Act. And in carrying out their duties, officials and functionaries are bound by the provision of that act. Clause 7 is necessary to ensure that the operation environment runs smoothly. There were also general comments and concerns that were raised. Other general comments and concerns were also noted, which mostly deal with operational issues. The department has confirmed that international agreements and procedures manuals will be developed and agreed upon by the states. Operational matters fall outside the scope of the bill and will be dealt with within those agreements and procedures manuals. Issues relating to corruption are sufficiently dealt with in other pieces of legislation, such as the Prevention and Combating of Crime of Corrupt Activities Act of 2004, and need not be repeated in this bill. The comment relating to funding mechanism has been noted. As mentioned elsewhere above, the bill is aimed at establishing a one-stop border post. Therefore, issues relating to funding, infrastructure development, technological improvement at ports of entry fall outside the scope of this bill. And in conclusion, the public submissions as they relate to specific clauses, including the general comments and concerns, have been noted and carefully considered. There is therefore no need to incorporate any of them in the bill given its objectives. I thank you.
Thank you very much, both Advocate Malekate and Mr. Lehotlo, for the two presentations, responses as a result of conversation between the portfolio committee and the stakeholders during the oral and written submission, and the summary that was carried by our content advisor. Members, I will invite you to comment on the issues that is being presented before the committee, or questions on the issues that you think need more clarity. Then we'll outline how we're going to handle this process moving forward. I'll recognize hands. Honorable Roos.
Thank you, Chair, and thank you to the department and the legal advisors. I think it was covered very well, the different material. Chair, I just have one outstanding concern, and that is regarding the clause 6. So the free transfer of money or goods within the common control zone. So if you look at other similar control zones like the EAC, the East African Customs Management Act, the fifth schedule certainly allows duty and tax exemption for government and state-related imports. My concern here is that if you look at the wording, it talks about the fact that these officials are not subject to the import or export and entry or exit laws of the Republic or the adjoining state. So this is talking about import and export, which I think we all fully accept in terms of taxes and duties. But it also talks about entry and exit laws. So I just need clarification on this, Chair, whether this is talking about every single element of having to comply with certain procedures as you approach the borderline, because it's not an unreasonable request to say, can we get a definition of official use? I went and looked. I tried to find where there might be a definition of official use somewhere else. If you look at some of the act in terms of now I'm losing it over here. Public Service and Administration Act. It's not in there. And there's some indirect references to it in those regulations. But Chair, as I read this in plain language, it seems to me that those persons, government officials, for official use, which is not defined anywhere in any law explicitly, and officials would need to refer to a dictionary, that they would then be able to come through, say it's official duty, and walk through, not be subject to even the entry or exit laws. So surely there needs to be a process where the goods are still checked and examined, and there's a manifest of those goods. Because from a transparency point of view, it would raise a lot of concerns if persons were able to arrive, not have to declare the goods, and just go through the border post. So I'd just like clarity on that issue, Chair. Thank you.
Thank you, Honorable Roos. Honorable Mudisim Msa.
Thank you very much, Chair. Let me also thank the responses that we have received from the members. Chair, I think also for us, we take note of the presentations and that there are no issues that we would want to raise. I think the responses from the department and that from the legal services are sufficient for us to move forward with the bill. So we are quite satisfied, Chair. Chair, we also take note of the concern with regard to the neglect, and we really hope that it won't hinder the processing of the bill. And if there's an opportunity for that concern to be clarified, we would appreciate that it gets to be clarified so that we are able to move with the processing of the bills smoothly. Thank you very much, Chair.
Thank you very much, Honorable Mdisemza. Honorable Thapelo Mogale.
Thank you very much, Chair. Let me also appreciate the presentation from the different speakers. And Chair, just on clause 6, which, like Honorable Roos has already highlighted, it's also a bit of a problem for me because, in its current, the way it is captured, it's I don't know. We already have serious challenges there at our borders with regards to corrupt officials. And I think this kind of clause, Chair, should have very tight measures in terms of addressing these corrupt elements, at our ports of entry. So I think it must really be tightened enough, not just because in its current form, Chair, it can be easily exploited by unscrupulous border officials. So I would really say that we need to tighten up that particular clause so that it deals explicitly, with corrupt activities that can potentially happen because of officials. Because I mean, it can easily be exploited in its current form. We know what is happening in our borders, so I would really call for a much more tighter wording in terms of how we deal with that clause. So that's the only thing I wanted to raise, Chair.
Thank you very much, Honorable Thapelo Mohale. Honorable Lerato Ngoben.
Thank you, Chair. Good morning to everyone. I think the appreciation has already been communicated by my colleagues. Chair, I just have one concern every time, and I'm not sure if I missed it in this presentation. I just want to get a sense as to the funding that's going to assist in this regard. As you know, BMA is already completely underfunded. And then you've got this one-stop border post proposal. Can we just get clarity as to the funding? Where is it going to come from? And it's supposed to be finalized this year. In terms of the timelines, I just want to understand, are the timelines still realistic in terms of the implementation of the one-stop border post? I just want to get a sense as to those two aspects of this process. Thank you.
Thank you very much, honorable members, for your comments. I also have two issues to raise. I think on clause 6, Honorable Mohale has labored on, and Honorable Rose, in terms of the established measures that may need to be put in place to respond to the issues that may be or may vulnerable at the border, as highlighted by members. The other point, I think when you were presenting, particularly Advocate Malekate, you refer to the standard international protocols in relation to the clauses that you have highlighted. And I'm sure it could have been served well if you could have demonstrated those reference of international treaties that South Africa is engaged on. And I'm sure that you are noting that we are raising these points because this is the first established one border stop border post and the legislation that is going to regulate its functioning. And all areas that have been raised by the stakeholders and ourselves, but also your continuous reference to an established standard protocols, treaties that we have signed. It could be important that we also benefit from that, because this conversation is also can be used to inform the citizen in terms of this process that yourself as the Department of Home Affairs, you are engaging on, and the legislation that we are now facilitating. So it is important that those highlights are able to demonstrate that. The other point in relation to that, I wanted to check if there's no conflicting laws with other jurisdictions. And part of the issues that the stakeholders were raising is to grant more functions to officials. And your motivation is that they will operate within the domestic laws, but also with reference to the international treaties. So I wanted to establish if there's no, or both yourselves and the legal services, you have not established conflicting laws that may create an obstacle for the facilitation of this bill in relation to the disputes that stakeholders may want to engage on, take this matter to court because of certain issues that are not established and within the framework. The last point is on the issue that Honorable Modise Mta has raised. In fact, it's not the last point. Before that, the function of the police, you know that there's an engagement which ensued in the sixth administration in relation to the transfer of the police to Border Management Authority. And I think both yourself and Commissioner Mashepa and DM, you extensively labor on that so that we understand how it will find its way into this legislation. And I think it's reflective in terms of the function of transfer in the Border Management Act. And you seem to be highlighting that there's still an engagement, but there's no concrete established framework in this proposed amendment bill. The last point is on the, and I think I'll direct you to the Deputy Minister, the NEDLAC process. I think Honorable Modise has raised to this matter. And we know that is and also another leg of consultation of other various stakeholders at the level of the executive. And I think the response is not sufficient to say we note the concern that has been raised. And I'm sure all the bills that have been presented before the committee, critical bills, there was a reference or stages that was under, or you have consulted the NEDLAC. And if the committee we do accept this reasoning, it may as well say that we condone we're ignorant to the issues that have been raised by stakeholders. And if we're caught to Parliament that these are stages that are not being consulted with, we may find ourselves in a wrong space. So I wanted to get a sense from the executive, or to submit to lobby them that there must be a way to satisfy that that process, or what are the mechanisms that we think we can raise to that. I'm just raising it because it has now landed in our court, and we can't ignore it because it's a critical area for a proper consultation, as the whip has raised. So I'll invite Advocate Malikate and the Commissioner of BMA, the Parliamentary Legal Service, and the Deputy Minister to respond to the comments that members have raised. Advocate Malikate.
Thank you, Chair. I think the question from Honorable Ross. I think we could just indicate that we should take note of the comment that has been provided. And I think if there's an issue relating to the definition of what is meant by official use, and if that would be sufficient to ensure that the readability and applicability of the provision, I think but we will leave it to the committee. We could in the provision then insert a subsection that then defines, for purposes of this legislation, what then is meant by official use, and just simply indicate. And I'm not providing a concrete suggestion on the wording, that we could just simply indicate that for purposes of this provision, official use means any good that is used for purposes of executing the functions of an official within the one-stop border post, and exclude something. So we are amenable to that, and we will leave it to the committee to then provide guidance as to whether or not we should consider inserting under that clause a definition of official use. And I think that would then deal with what Honorable Mohale has also indicated in relation to clause 6, as well as what Chair you have indicated relating to deal with issues relating to the potential abuse of the provisions by those who can take advantage of the mere fact that anything that they may possess or they have in them is exempted from taxation. So we will leave it to the honorable to the committee to advise and decide on how we should then deal with it. And I think relating to the NETLAC process, Chair, I will leave that to my deputy minister. And I think the issues related to funding, I think the commissioner for the BMA should be able to deal with it sufficiently. Chair, relating to the international instruments, I think we may just try in the next meeting to demonstrate some of the international instruments that South Africa is signatory to. But these treaties, they fall within the Department of International Relations and Cooperation. They have a desk that is dedicated to compile a list of the treaties of all treaties that South Africa is signatory to or has acceded to. So, but in the next meeting, Chair, if it would be allowed, we can then demonstrate some of the international instruments and protocols that South Africa is signatory to that impacts on border management. Chair, you are correct that there may be a conflict between legislation for the Republic and the legislation for the other country as it relates to border management. But we are of the view that when we are dealing with the procedures manual, we would then be able to reflect on what laws are there in the adjoining states that impacts on the effective and smooth running of a one-stop border post, and how do we then deal or find a way to harmonize the legislation for purposes of ensuring that we then have an effective OSBP established. But we think that this bill should not be dealing with that conflict, but that the international agreement that will be concluded, or the procedures manual, should properly then deal with how we then resolve the conflicts as it relates to the laws that are applicable, which may be an obstacle in the proper establishment of the OSBP. Chair, I will also leave the question that you have raised relating to the efforts or the conversation that are being had in relation to the transfer of the BMA. Safe to indicate that if we were to look at the objectives of this bill, those issues relating to the transfer are outside of the scope of this bill. But I think the Commissioner for the BMA would be able to properly provide a response to the question that, Chair, you have raised. Thank you, Chair.
Thank you very much, Dr. Mashapat. Is the doctor in a meeting, Mr. Matonto? I was advised that he's in earlier on. Okay, let's invite.
No, sorry, Chair, it's not in the meeting. I didn't see him earlier on as well.
Okay. I think the DM will have a way to deal with those issues. Mr. Mashokwa? Is there any other matter you want to respond?
Honorable Chair, no, I think every other concern have been dealt with ably so by advocate. I do not have anything from my side to clarify unless there is a specific question, but for all those concerns that have been raised, I think they've been adequately dealt with. Thank you.
Okay, thanks very much. Let me invite maybe TDG Yusuf. Is there any other matter you want to respond? Okay. Can I now invite the Deputy Minister?
Oh, thanks.
Sorry, DM. Chair, my hand is raised. I'm not sure who's going to deal with the funding issue. Thanks.
Deputy Minister, proceed.
No, thank you very much, Chair. I don't know what happened to Commissioner. He was in the meeting when we joined the meeting, but I will have a chat with him outside of the meeting. One, I think there are two issues that I'm expected to respond to. The first one is around the issue of the operations for the BMA, mainly dealing with the issue of transfer of powers between the police and the BMA around the border environment. I would suggest, Chair, that on that one we take a specific brief to the committee to deal with that particular matter, and probably also rope in the SAPS so that we can deal with it holistically. Because there are currently discussions that are being led by the Minister and the Minister of Police that are still going on. At the core of everything, Chair, it is around the police doing border law enforcement around the area, vis-a-vis it being done by the BMA, and the resources for border law enforcement that are currently sitting with the police, and how do we then transfer, whether we transfer the whole people together with the funding, or we just transfer the funding alone and then deal with the issue of recruitment for the BMA to particularly exercise that particular function. So I will suggest, Chair, that we probably have a specific brief on that matter to the committee. On the one of the network, Chair, I think we'll just take your advice on that one. We'll look at the issue closer up until all conditions are satisfied, and we continue engagement with the network. On the issue of funding, I'm not sure if we are referring to the funding for the one-stop border post, as in the 6 ports of entries, which are currently undergoing a triple P process. And initially, the funding was meant to be in a triple P format, which would have meant that we do not place a lot of reliance on the state resources, but also roping in the private sector. There are discussions that are going on with National Treasury on how we can mitigate those funding alternatives. But I remember, Chair, I think we were tasked by the committee to prepare a brief on how far we are as it pertains to the development of the 6 ports of entry. We did deal with that particular item within, and we are ready to report. I think at any given moment of time, we can give you a full report on those aspects. But safe to say that we're at an advanced stage of the PPP process. I think very soon we'll be concluding the process. As you will know, that we will not want to deal with the procurement specifics whilst we are here. Even ourselves at a ministerial level, we don't deal with the procurement specifics. But what we know is that we're at a very advanced level. In fact, I think in a matter of a month or so, we should be looking at the processes being concluded. But the funding for that was initially meant to be a PPP process. I know that Treasury has indicated that they might be making some funding available for that particular project. So we don't have a crisis in terms of the development of the 6 ports of entries. Thank you, Chair.
Thank you very much, DM. We noted that Dr. Mashaba.
Okay.
Is there any intervention somebody want to make?
Oh, no, it was me. I wanted to indicate that Dr. Mashiapo is in the meeting.
Thanks, DM, for those responses. Dr. Mashapata, Commissioner, I'm not sure whether when members were raising comments or questions, you were still in the meeting in relation to other areas related to the BMA and the one-stop border post, including the last remarks of the DM. There was a matter around the budget or the model of the funding for the one-stop border post, and any other matter that you may want to raise, Commissioner.
No, thank you very much, Chair, and apologies. There was a bit of a technical challenge that I faced when the members were raising questions. But in terms of the, let me start by reflecting on the issue of NETLEC. I do note that there was an issue raised, especially from COSATU submissions around the NETLEC issue. And I want to indicate on that particular one that we have been able to address the NETLEC challenge. And I think the issue that had fairly been emphasized was the initial reality, which had actually happened before, where there was some bit of a jumping of the NETLEC stage, as it were, to the extent that even when we went to the Public Service Coordinated Bargaining Council, there was that reflection. So what we then started doing was to make sure that we have continuous engagements with NETLEC, even during the process of the ultimate, BMA establishment and all of those, we were engaged with them, to the extent that even the aspect of the bill itself, I was there with Advocate Malakati in terms of the OSBP bill to NETLEC, and we deliberated on that. And I also want to confirm that those conversations actually continues. Just to indicate, this Thursday I will also be appearing before NETLEC, also to deliberate on the full operationalization of the BMA and all of that. So that aspect, I just wanted to confirm that it is fairly addressed. The second issue, Chair, around the issue of the funding in terms of the implementation of the one-stop border post. Remember, the issue in terms of where we are going to start in terms of its implementation is going to be on the 6 ports that the DM had spoken about, which are to be redesigned and redeveloped. So in terms of those particular 6 ports, that is where we are going to be implementing the one-stop border post. And in terms of its implementation thereof, the expenditure or the budgeting in as far as its implementation is on the basis of the PPP, the public-private partnership, the designing in terms of the buildings and the creation of the rooms or the places where the work is going to be covered. So on that particular basis, that aspect is actually going to be covered by the actual PPP implementation. A typical example is, for example, if you are to look at Bait Bridge, the Zimbabweans have already redesigned and redeveloped their side of the port. They are just waiting for South Africa to be able to catch up so that we can then move towards the implementation of the one-stop border post. But what we have been doing in the intervening period is basically engaging with our neighboring countries, particularly around the synchronization of our standard operating procedures, and make sure that there is also going to be the alignment in terms of the legislative frameworks. And we did confirm to them that on our case,
the OSBP, the OSBP Act, ultimately when it becomes an act, is going to be a foundational legal framework that we're going to be using to implement the OSBP. And of course, on their side, as respective countries, they're also doing the same. So I can indicate that we are just waiting for infrastructure to be able to actually implement the model going forward. And to that extent, there is not necessarily any challenge, as it were. And those meetings actually continue. And maybe the last thing, just to give comfort to the committee members, Chair, is also to indicate that this particular model, within the context of its implementation, is also accounted for in the binational commissions between us and our respective neighborhood, which are basically led at the presidential level. So there is no any kind of confusion per se at the highest level. The only issue is just about to get the bill into a law and ultimately get infrastructure ready, and then we should be able to start implementing. We are going to do it gradually. It's not going to be the case everywhere else. We are going to start at our top land ports, and we will gradually go until we are covering all the commercial ports, and then we'll be able to take it forward. Thanks.
Thanks very much, members. Is there any other matter? No, thanks very much, honorable members, and thank the DM, Advocate Malikate, Mr. Mashokwa, and the Commissioner for the presentation and the responses on this matter. We agree, all of us, that you must come back to demonstrate on the issues that have been raised by the members of the committee, particularly on the procedure manual and the areas where there can be conflicting legislation by other member states, but also on the full funding model, as we know that you are also proceeding to the 6 ports of entry through the PPP, but also the engagement with the national treasury on that front. So I want to also note the matter of engagement with the police. I will propose that we take the same route we took to probably engage with the portfolio committee on the police, just a joint meeting around this subject matter. We can invite both the executives or the PMA or the commissioner of the police. It's a matter that we'll have to navigate with the chair of the police on how we can deal with this issue. It has been raised even in our debate when we're engaging. All of us, we know that there has been engagement previously, even in the 6th administration, between the then ministers, Pegikele and Minister Dr. Aaron Nzwaledi. And I think we must also assist the executive, both the minister and the DM Home Affairs, to interface with the counterpart of the Home Affairs, the police committee. We'll then have to leave these presentations and all the issues that yourself, the DM, and the team will come back for conversation again, for members to go back and refine some of the issues that they may be raising. And also you have indicated, Advocate Malikate, on the areas that you need to interact with the DECO on the issue of international standard practice that you have also highlighted in your response, and also continuous engagement with the NEDLAC around this matter. So I think that is sufficient for these 2 items that we have dealt with in today's portfolio committee meeting. We'll then have to reschedule again to proceed with this matter. Is also an important area that the committee must conclude, so that at the time that also the process at the level of the executive is being concluded, there's also a will running on our part to effect this legislation for a report and consideration in Parliament. Thank you very much. We'll stand off this item, and I want to thank all of you, honorable members, DM and your team, you can be released. Then we'll move to the last item. Mr. Matonze?
Yes, Chairperson. Yeah, I'm just okay. Chairperson, this is an update of our schedule for public hearings in the Free State and also as well in the Northern Cape. For the Free State, it will be on the 25th and 26th and 27th. And then we are leaving to go to the Free State on the 24th, which is on Thursday this week, on Thursday this week. We have in the Free State secure venues. So these are the venues that have been indicated on the schedule here. Then I will also email I think I've emailed it already to members. And then yeah, Chairperson, as I've indicated, we're traveling to Bloemfontein on the 24th of July, and then we have got accommodation there at the Southern Sun Hotel Bloemfontein. And then on the 25th, and then we've got public hearings as indicated on the venue there. After the public hearing, Chair, we travel to Welkom, and then which is 154 kilometers. And then we have public hearings. Will be accommodated at this Old Jardine guest house. I just got a message from Mr. Aaron said that that guest house is fully booked, but I think we'll be working on an alternative venue accommodation for us when we arrive there. I think it will be sorted out between today and tomorrow. And then in Welkom, we'll do public hearing on the 26th. And then the committee will sleep at the Protea Hotel, Bamia Road at Clarence, which is about 33 kilometers to Bethlehem. And then we are going to spend 2 nights in Bethlehem, the 26th, and then also the 27th. The reason being that from the 28th, members have to drive to Johannesburg. The distance from Bethlehem to Bloemfontein and also from Bethlehem to Johannesburg, they are almost the same. So I thought, no, it would be better if members just drive in the morning of the 28th to Johannesburg. And those who are flying out, and then they will fly out. And then, yeah, just to indicate that, Chairperson, we submitted the applications for both the Free State and the Northern Cape, and then it was approved. As I've indicated, you know, the flights have been secured from the information that I got from Mr. Arendse. Then accommodation has been secured, except in Welkom, that it will be sorted. And then we've got ground transport as well. And then I'm sure also the tickets for the flights have been issued. Members could have received SMSs for their flights. And then also the correspondences were also sent to the legislature, the Free State House of Traditional Leaders, the Premier's office, then the Mangaung District Municipality, then the district municipality and the local municipality, the Majabeng local municipality. That's where the hearing will take place, Thabo Mfusanyana, and then the Tlhabeng local municipality. And then, as I've indicated, you know, the venues have been secured. Then we're assisted by household services, Parliament household services with the venues, and then they have been confirmed. And then I was also informed that, you know, the official from household services is traveling. I think she could have left yesterday to go to those venues just to ensure that, you know, everything is in order. And then catering for all the provinces, you know, the Free State and also the Northern Cape has been approved and then finalized. Transport plans, especially for the Free State, we'll be getting them by today and tomorrow for further processing. The transport plans these are plans that the officials from public education and public participation, and as well the parliamentary democracy offices are working on with the local municipality to transport people from a radius of the venue of the meeting of 100 kilometers. So they bringing in people there. And then also the SCM has been also be working closely with our colleagues in admin on the issue of catering, securing the service provider for interpreting, audio, ICT, and requisition of equipment that are needed in the halls, such as tables and chairs where they are needed. And then also PCS communication, they are ready to assist with social media, posters, video, and the unit will also be assisting with branding. With the posters, there's one that Malatswa has done already, and he has put that in the group of in the WhatsApp group, and then we're just waiting for the video that will be done. And then languages on the 25th, which is Friday, and then the language section indicated that they will use a service provider there, but on the 26th and 27th, they might use also parliament language interpreters, because I think they were going on to recess. And then these are the languages that have been identified, you know, in Mangaung, Sesotho, Afrikaans, isiXhosa, sign language, and English. And then in the Litjolaputsa, DM is Sesotho, Setswana, Afrikaans, isiXhosa, sign language, and English. Tabamfuzanya, Sesotho, Afrikaans, isiXhosa, sign language, and English. And then we're also been assured that Parliament Protection Service, they are ready to be accompanying us and also assisting us during the public hearing. And then also they are working together with the traffic cops and the police to conduct a threat assessment. So they also indicated that EMS will also assist in case of emergency. So they are in contact with the people there. In terms of the public participation unit, I only received a report for the Free State. I think for Northern Cape, they are still working on it, since the hearings there will be taking place at the beginning of August. So for Mangaung, they've done 7 engagement with 127 people. This is as of last week, Chairperson. And then 127 people have been reached, and then publication that were disputed is about 622. That is Mangaung, Litjolaputsa is 7. 108 people were engaged, and then 150 publication has been distributed, has been distributed, Chair. Thabo Mfuzanyana is 6, and then number of people is 56, and then publication distributed is 56. As you can see here on the side, Chairperson, with radio, it says none, because it looks like public education, especially with the community radio station, they don't have budget for it. So unless if they piggyback on government GCIS for them to be able to broadcast on a community radio station. So Chairperson, these are the stakeholders that they have engaged in the Free State: municipal councillor, traditional council, church leaders, works committees, health workers, Men's Forum, FAMSA, SANCO, GCIS, Home Affairs, CDS, NGOs, people with disability, and LGBTQIA+ community. That is basically for the Free State that we are going to be starting now. For Northern Cape, Chair, the public hearings will be on the 4th. Then will be on the 4th in the Francis Bath District Municipality at Salt Blackie in Kimberley. There we have a venue there, Halishiwe Recreational Hall. And then on the 5th, we've got John Khaitsiwe Municipality there at the Sehonyana Municipal Hall. I'm just still waiting for confirmation of the venue for the David Creeper in Uppington. So in terms of the logistics, we're leaving on the 3rd of August. Then accommodation will be at Kimberley Inn Hotel. And then we've got the public hearing on the 4th of August. And then after that public hearing, then we travel to Kuruman, which is about 239 kilometers. And then we sleep at Ahakatu Hotel. We'll stay for 2 nights there. The reason staying for 2 nights there, Chairperson, is that if you check at the here, we've got the public hearing on the 4th, and then the 5th, and then the 7th. So there's no 6, which means the committee will spend 2 nights at the Kuruman. So in other words, we have a public hearing on the 4th. Then we sleep there, and then we've got and then also on the 5th, and then on the 6th of August, that's when we check out, and then we travel to Uppington, which is about 2 hours, 44 minutes, 263 kilometers. So that the 6th will be a traveling day only. And then accommodation is Proti Hotel by Marriott Uppington. And then there, the committee will have public hearing as indicated on the 7th. So we'll sleep there on the 6th and the 7th, and then on the 8th, depart to Johannesburg and Cape Town. So, Chair, as I've indicated, here is the same thing. Then all the letters were sent. I won't go through. Is this almost the similar process that I went through on the Free State, that where letters were sent. And then I'm also indicating here that we only secured 2 venues. We're still waiting for the confirmation of the venue in Uppington. As I've indicated as well, catering has been finalized in the Free State. And then we're also waiting for transport plans, especially for Northern Cape. They still have got time because the public hearings are in August. Then SEM is also assisting with catering, securing service provider for interpreting, audio, ICT, requisition within where the venues equipments are needed. And then also here also here is that the PCS is also going to be assisting with the social media, posters, and video deployment. I think we're just waiting for the confirmation of the venue, Chair. Language, because the public hearing, especially in the Northern Cape, will be taking place during recess. Parliament will check the availability of Parliament interpreters, because during the recess, that's the time when staff take leave. So they will let me know how many interpreters from Parliament. They will complement that with a service provider. Then the languages that are going to be used there are Setswana, Afrikaans, Xhosa, and sign language, where I hope I'm pronouncing it right, and English. And then, Parliamentary Protection Service, as I've indicated, they are going to be assisting us. Then, in terms of the public participation unit, that is the public education, I have not received anything. I think I will update this and send it over to members as soon as I get it. Thanks, Chair. That's all from my side.
Thanks very much for the update. And also note that today we're joined by Honorable Shangase in the committee. Mr. Salmon, before we comment, I see you raising your hand.
Yes, Chair, just to indicate that the public education numbers for the Free State, they're still ongoing. They're occurring even as we speak. So those weren't the final numbers. There will be more prior to the public hearing starting on Friday. So those are not the complete numbers as far as I understand. Thank you, Chair.
Okay, thank you very much. Is there any other comments you want to make, officials, before I invite members?
From my side, Chair, there's nothing.
Okay, members? Honorable Ngobeni?
Thank you, Chair, and thanks, Mr. Matonsi. Mine is really times, travel times, flight-wise, because I don't have that, so I have to make my own arrangements. Can I just get schedules in terms of flights to the Free State and also to the Northern Cape? Thanks.
Any other comments? Honorable Bolman?
Thank you, Chair. Thank you, Eddie. I just would like to confirm that the traveling via the airports is going to be confirmed. And the only reason I'm saying this is it took me about 6.5 hours to get from Durban to Cape Town yesterday. There is mass confusion and chaos at the airport with the FlySAF Air flights, which is creating a knock-on with other aircraft carriers. So I think if that can just be checked so that we're not caught short again with our travel times and we overlap like we did last time. Thank you very much, Chair.
Okay. Any other comment? Is there any other traditional authority the committee is expected to visit? You recall in our last public hearings, we had to apportion members to go to visit the traditional authority, and others continue the public hearings. Are we going to, is there any other issue to deal with that? Secondly, you have heard Honorable Ngobeni that she is traveling outside the committee. There are three members who are alternate in the Committee of Home Affairs. And the matters in relation to alternatives who must attend either public hearings covered by Parliament has been deposited to the Chair of Chairs for a conversation. I think it's a matter that resides in the Rules Committee. We have deposited it to the Chair of Chairs, and I think with the leader of the minority parties, or the smaller parties, I'm not sure they've categorized parties, Honorable Ghana, I think will respond, and also the chief whip of the majority party. It's a matter that I think is across committees that have raised. So I just want to highlight that point. The issue of the distance appear to be also coming again. You may need to check it to what extent it's going to travel. I have not been traveling to that area of the Free State. I was advised, Arends, that traveling from Joburg up on the lineup that you have highlighted is more closer. Then you can fly in Bloemfontein when you have concluded your public hearing back to OR Tambo. I'm not certain around that area, but also some of the issues that members are raising, if we can get a sense of comfort on those issues that members are raising. Mr. Matonza?
Yes, Chairperson, in relation to Ms. Ngobeni, I think I had a conversation with her yesterday regarding the Free State that she's going to be participating. As you have correctly mentioned, Chairperson, that is the situation at the moment because she's an alternate in the committee. But for the Northern Cape, I spoke to Thursday yesterday. He indicated to me that Ms. Matopa, who's a permanent member, she has withdrawn for the Northern Cape. So I've asked Mr. Arends to send to Ms. Ngobeni the travel confirmation so that I can do a memo with the budget in terms of the flights and the accommodation so that I can submit to the House Chair. But that would be for the Northern Cape Chairperson. And then in relation to the issue of the traditional leaders, we had a meeting with the public education, I think twice already, Friday and the other Friday. And then we are planning to have another one tomorrow. And then we have raised this with them to say, this is what happened in my game, and then we are avoiding it to happen again. So we have requested them to say, if in the area where we're going to have public hearings, then there's it falls under a traditional leader that if they agree we need to pay a courtesy cost, then they must let us know on time. But as well, for all the traditional leaders that are coming to the public hearings, including MPLs and everybody, that they must let us know so that we know on time. You will recall, Chairperson, most of the time when, especially with MPLs and councillors, we only know about them when we're there at the meeting, but especially with the legislatures, we also indicate to them, they must indicate if there's going to be MPLs that are coming to the public hearing, so that at least we also make extra space in front. So, but most of the time it doesn't happen. But we'll also emphasize this issue of the traditional leaders, Chairperson, and then we'll let you know on time whether there would be a need to do a courtesy call or whether there would be traditional leaders that are coming just for noting. I'm not sure if there's anything that Adam will want to add and RNC.
Honorable Bowman has raised a matter.
Yeah, I think, Utheston will check. I don't know with the strike, but I think we are using a link. I don't know how it affects the travel at the moment. So it's a dicey situation because the flights that we have so far, if I remember, is a link that we're using. So I'm still to be corrected by Mr. RNC if maybe other members are using other airline.
Okay, can we then establish all the issues that are being raised by members and it becomes a working assessment from your part, and you'll update the members, particularly on administrative issues that must comfort members' travel and participation. So let's leave it at that point and check the details and all the issues that have been raised by members. Members, I think we take it as an update for the readiness of the public hearings. There's no any other matter in the agenda, I guess so, Mr. Matonzi?
Yes, there's no other matter, Chair.
Okay, thanks, members.
There is a hand.
Yes, Chairperson.
Yes.
Can I proceed?
Proceed.
Oh, thanks, Chair. No, man, Chairperson, I just wanted to understand. Maybe I did not hear the explanation provided on the continued absence of the minister from the committee. I think it's something that we note with great discomfort because he's the minister responsible for this department. And this is now, I think, the third time that he has been missing from the portfolio committee. And there are issues that I think we would also want to take up with him because we are seeing him internationally now when there are issues here at home with regard to some of these home affairs offices. So maybe if we can get an explanation why the minister has not been seen in this committee, it would be proper.
Thank you. Is the DM in the meeting? Is still in the meeting?
Yes, Chair, I'm here. I'm in the meeting.
Oh, yeah. I don't want to. I think that's a matter that has been raised. DM. There's a serious concern. We've been raising it. And I think we thought that by today, the executive could have visited the Umtata office. And instead, they have crossed the borders to intervene when there are challenges here. I'm sure that you may not take accountability, but you can respond and also communicate our message. It's a matter that also we'll deal with in the next committee meeting. I thought it's an important area which we need to navigate around. Maybe we've caught you out of guard off guard, DM. But if you have details of the absence of the minister, you can comment. DM.
No, Chair, I will rather not comment on the issue. I think the minister will be able to deal with the matter. I know that the minister did inform me that he was going to the office opening in Australia, but we did not have a chat today or yesterday. Thank you.
Okay, so I think you may need to communicate with the minister around this matter. We'll also formally communicate to the minister around the issues that we have referred previously and they've not been attended, including the area we visited, the Umtata office. Yeah. Thank you, members. I think we'll leave it at that point. And thanks, honorable members. Thanks, DM. Thanks, and your team for the contributions to this portfolio committee meeting. The meeting stands adjourned.
Thank you, Chair.
Thank you, colleagues.
Thank you,
Bye-bye.
Chair.
Thank you, Chair.